Well, here we are again. We are on with our Exhibit A. We've been gone for a little while, but in 2024, there was a lot of cases. We didn't really cover them in Exhibit A, but we're on it for 2025. We're going to start off with a really interesting case. It deals with an extension of a domestic violence restraining order. And with us, we have my partner, Casey Marticarena, who I love having on the show because she's so good at breaking these cases down and making it really clear as to what the meaning is. So you don't have to be an attorney to understand this. Casey is very good at communicating what the law is and the facts. And stand by, because this is going to be an interesting one. So, Casey, thanks for joining me.
Thank you for having me, Don.
And why don't you set up the fact? Well, what's the name of the case?
So this is Navarro and Cervera, and it is a case on a renewal of a restraining order. So the restraining order has already been granted and it's going to expire. So it's where the petitioner goes in and asks the judge to extend it for 5 years or permanently. And there's a slightly different analysis that you have to apply. So that's what this case is. It's about specifically the renewal of a restraining order when it's going to expire.
Okay, so just to make it clear, is we're talking about renewing a restraining order. This is not a case about obtaining the original restraining order.
Right,
Okay.
absolutely.
Okay, so what are the facts of this case?
Okay, so to set up the facts, we have a couple in a dating relationship. They were dating for 8 years, and we're going to refer to them as petitioner and respondent, just to keep it very simple.
Or defendant.
Or excuse me, defendant. So we're going to refer to them as petitioner and defendant, just to keep it very simple. So the defendant here, during the dating relationship, had some mental health issues. There was a diagnosis of borderline personality disorders. There was some history with suicidal thoughts, fascination with murder-suicides, and prior history with 5150 holds, which are mandatory hospitalizations. So this is kind of the backdrop of the defendant in the case. Parties broke up, and then after the breakup, the petitioner in the case started getting phone calls from the defendant's family, indicating that the family was concerned for the petitioner, concerned that the respondent was going to come after her and try to hurt her. So anyone in that position would have some cause for concern.
Yeah, and I think you said that not only was there a suicidal ideation, but according to the appellate court decision, she attempted suicide on multiple occasions and had a fascination with murder-suicide. So in my book, this is somebody that's very unstable. And, you know, the fact that family members are calling you, warning you that their own family member is, you know, doing things, saying things that causes concern, this is serious.
Absolutely. And that's kind of the backdrop to the moving party and the petitioner, the reasonableness of their fear and their state of mind. I think anyone in that person's position would be scared. If you have family members calling, and also there's this history of suicide attempts, like you mentioned. So fast forward, the next step, the next thing that happens is the moving party, the petitioner is leaving work, and the defendant is found to be in the parking lot, tries to break into her car, things like that are scary. Then the police arrive. The defendant, the case uses the word acknowledges that she was there to try to kill the petitioner, right?
Yeah.
So
Oh my God.
I almost felt like the word acknowledge was too soft. It's really an admission of an intent to kill. So that's why she's there. She's there, and I think she was found hiding, and I think she had materials that she was going to use in furtherance of this plot to kill.
Yeah. So if we could just pause here for
Absolutely.
I'd add a little bit of juice to the facts, like I like to do. The appellate court decision states that the same day as the petitioner is arriving to work, the defendant rushes her car aggressively and attempts to enter their car. And from what I understand is she was actually got into the car and said some things that were kind of scary. When the police arrived, she's hiding with a kitchen knife in the parking lot and acknowledges she intends to kill the petitioner, and further states she had previously broken into petitioner's apartment with the intent to kill her and herself. Now, these are facts that are for the underlying restraining order, right?
These are the underlying
Okay.
restraining order. So this is, no one has set foot in court yet, but a petitioner went to court. She was able to get a 5-year restraining order. There's a little nuanced fact here that the police officer did not testify at the trial. So the court did not consider the attack an attempted murder because the police officer did not testify at the hearing. But the court found that the petitioner had reasonable apprehension of physical harm. So all of that to say that the act of being at her work, hiding out, trying to get into her car, all of those things would place the petitioner in reasonable apprehension of fear. But the court did not necessarily take into consideration that it was an attempted murder. That's just a little nuanced fact to make the point about how you prepare for any type of proceeding. It might be very important to get the police officer.
The police
there.
officer, because what could the police officer have done if called into court?
The police officer would have testified as to the
Seeing her-
party's admission.
And seeing her with a knife,
Right.
and how crazed eyes and all that stuff, right?
Absolutely. So, okay, there's a restraining order granted. Now we're at a point where we're at the post-restraining order facts. Should I get into those as
Sure.
well? Okay, so the restraining order is granted. A year later, the defendant violates the restraining order by emailing and texting. Now, the restraining order means no contact, direct or indirect. No phone calls, no texting. That is a very clear black and white boundary. So the defendant violates the restraining order by emailing and texting.
And what she says in her communications apparently is, I'm not supposed to contact you. I love you then and I love you now. And I don't care if I go to jail. You are more important, right?
Right. And reading those communications, that's important for a couple of reasons. Number one, she admits in those statements that she understands the seriousness. She understands the boundary of the restraining order. She understands the seriousness of violating it. That is, she's going to go to jail, but she doesn't care. So I think that's really an important detail because it shows that this person has lack of impulse control and also has a difficult time respecting boundaries.
Which would cause a person reasonable fear in most cases. Really, it's not a matter of showing this evidence to prove intent, because intent's not a issue at this point in the case, or actually in any of it. It's supposed to be, how does the petitioner feel about that, right?
Right. The petitioner's state of mind. There was also a letter. There's some kind of the defendant denies that she sent the letter, but there was a letter that was about reconciliation with the petitioner. The petitioner is now filing a request to renew the restraining order. She's required to do so before the restraining order actually expires. And the case now kind of gets into the reasoning for that request. I mean, we can talk about kind of what her reasons are, or we can give it a backdrop as far as what the law and what the analysis would be there.
Yeah, I don't think that this is necessarily highly relevant to our discussion, but my notes show, and maybe you could confirm this, that the petition reports these communications to the police and obtains a 3-year criminal protective order against the defendant, which to me means that she was then criminally prosecuted for violating the restraining order. I'm just reading between the lines. I don't know.
Absolutely. So
Okay.
So that means that the backdrop of this request for renewal in family court probably had a criminal protective order already in the background, which, by the way, we're here on appeal because the writing on the wall is that the lower court denied the renewal. So that additional fact tends to show that this is really a bad decision.
Yeah.
So that's where we are leading up to the renewal. Those are the facts leading up to the request for renewal.
Okay. And so she seeks a renewal, and so how does that go? What was the discussion between the petitioner, and the court, or what were the arguments?
Well, why don't we why don't we start with the backdrop of what the analysis is supposed to be?
Okay.
So a renewal of the restraining order is Family Code 6345, and it permits the court to extend the term of an order without showing further abuse since the issuance of the original order. So I've already said it could be 5 years or it could be permanent. What's the analysis? The analysis is the court has to assess whether a reasonable person in the petitioner's circumstances would fear repetition of the abuse if the order expired. So whether the petitioner fears repetition, number one. Number two, there's no requirement that there has to be a violation of the underlying restraining order. So that is kind of the setup. Beyond that, this case outlines what they call the Ritchie factors. It's a multi-factor analysis on what the court should be looking for. The court should be looking at the underlying event and analyzing that, and taking a look at the underlying facts that support the order. Number two, the court's going to look at whether there's any significant change in circumstances. For example, the parties now live 300 miles away. They're both remarried. They've had no contact. So that was considered a significant change in circumstances in another case that disfavored a renewal.
Because the person had moved on, as the Court of Appeals stated.
Exactly. They've moved on and they're remarried, and there's no kind of further need for this restraining order. The third factor is the seriousness and the degree of risk. Okay, so and there is a fourth factor that they enumerate, kind of lumped into number three, but that is the burden on the defendant. In other words, does this restraining order cause the defendant to not be able to take jobs, not be able to, move freely in a city where they grew up and all their family is? So the court also can look at the burden on the responding party or the defendant. Now, the court also clarifies that if there's a risk of physical abuse, that factor number 4, being the burden on the respondent or the defendant, is irrelevant. Okay? So just to sum that up, we're looking at the petitioner's reasonable apprehension of fear and their the risk that the abuse will be repeated, and then we're looking at those 3 Ritchie factors.
So that's the standard of the law. That's the statement of the law, and that's what the judge should have followed. So
Right.
Can I just interject what the defendant argued on appeal as to why, despite all of that, a restraining order should not be granted. So I'm going to be the attorney for the defendant in this case and note that in December of 2019, she did, in fact, send a letter, but nothing's happened since then. It's now May of 2023. There's been no further incidents that my client has been engaged in to cause your client any fear. She's definitely moved on, and so these fears are not reasonable, since the 2018 incident was a result of a mental health crisis, and they've been resolved. She doesn't have any access to weapons. She hasn't had any contact with your client in 4 years and doesn't even want to contact her. So why shouldn't that be granted?
Right. So to sum up, you've
Or
outlined.
I should say, why shouldn't that be granted? So why should it be granted? There's a lot of burden on my client. She hasn't done anything in 4 years, and now you want another restraining order put on her? Doesn't seem right.
Right. So to sum that up, if you're representing the defendant in this case, the defendant is saying, I haven't contacted this person in 4 years. There's, number one. Number two, by the way, I was having a mental health crisis, and that has since resolved, and I was on some terrible medication, and I'm not taking that medication anymore. Also, I've now been diagnosed officially, and I'm receiving treatment. So there's really no reason for, and by the way, I feel bad about what I did, and I take accountability. So that was basically the defense in this case.
So after hearing the defendant's argument, I believe that the petitioner countered by saying, hey, look, this is nothing new. She's been on and off medication throughout the relationship. She's been in treatment, and the fact that she might be, now not having episodes or not doesn't alleviate my fear, because I know what the history of this has been, and that's why I'm asking for the restraining order.
Right. So essentially that despite an apparent change in medication, there was still text messages and a letter that came a year later or 2 years later. So there was still that post-restraining order conduct. All of that to say that the diagnosis and the new medication didn't change the behavior, and that this is a person that needs strict boundaries.
Okay. So how does the trial court deal with this?
Well, the trial court, there was a whole analysis. I mean, the trial court felt that there were mitigating circumstances, that it'd been 4 years since the parties communicated, that the mental health issues were alleviated, and the trial court actually took this as an isolated incident, being the plot to kill at work.
So from my reading of the case, Casey, is that the trial court finds that the petitioner did not meet her burden to show that she was truly and genuinely fearful, and that's why it denied the renewal of the restraining order.
Right. The court felt that there were mitigating factors, that it had been 4 years since they had any communication, that the mental health issues were alleviated. So for all of those reasons, the court denied the renewal of the restraining order.
Okay. And apparently the petitioner appeals the decision.
The petitioner appeals the decision, and there was a detailed analysis in this case going through the family code and also the Ritchie factors, going step by step to evaluate whether the court should have renewed the restraining order. Okay, so the court starts with an analysis, and it starts with the underlying incident. And the court feels that the underlying incident is egregious, that the defendant broke into the moving party's home with an intent to kill her. We know that the defendant was at the petitioner's work with a plan to kill her, that a knife was found by the police, and that there was an admission of intent to kill during that incident. So the court found the underlying event, in its words, egregious.
In and of itself.
In and of itself.
So you don't need anything further to grant the extension, given the underlying incident.
Right, and to quote the case, they say, as explained in Ritchie, the evidence and findings on which the initial order was based are often enough in themselves to provide the necessary proof to find the protected party's apprehension is genuine and reasonable. And exactly that was enough. The court gives us further analysis all the way through the Ritchie factors, but the underlying event is enough. And that's one of the takeaways from this case.
Okay. So the Court of Appeal overturns the decision?
It overturns the decision, and then what it also does in its analysis is it goes into the mitigating factors that the lower court relied on, and it kind of dissects those, so to speak. So, for example, that the 2018 was a single isolated incident. The court says no. There were several incidents, including the incident at the petitioner's home, the incident at work, and then we know that after the restraining order there were violations of the restraining order. So, but as to the lower court's analysis, the Court of Appeal disagreed that this was a single isolated event. And then beyond that, as to the medication, there was evidence that no, after this medication issue would have resolved, there were additional incidents that happened after the restraining order that show that the person's conduct had not been alleviated. In fact, it was continuing.
Yeah, and I thought that was interesting in the decision. It said that the trial court erred by giving greater weight to the defendant's unsubstantiated justifications for her abuse and restraining order violations rather than considering the impact of those actions on the petitioner's sense of safety. And in that way, the trial court abused its discretion. So it didn't really do the right balancing test here.
Absolutely. And another nuance is that the lower court considered one act of physical violence as an isolated event, but the Court of Appeal says, no, you're not supposed to just look at whether there's one act of physical violence. You should look at the other acts as well, like the acts of breaking in, the acts of sending text messages and letters. So just one act of physical violence is not the analysis here. You have to look at all of it. There was also the issue of sending the communications. The lower court felt that there was like a reason, a rationale, a justification for those communications. The excuse was I was going through a mental health issue. Now, I like the language from the Court of Appeal. It says the rationale for sending the communications is not excuse because a knowing violation of a DVRO cannot be characterized as de minimis and technical violation.
That's a big one.
That's a big one, right? Because, I mean, it's black and white. It is a violation, period. And how the court needs something black and white to enforce, to analyze. If we are going to have a mini trial regarding each little incident to see if it is a violation, then that's not good for judicial resources. Also, law enforcement needs something black and white to enforce.
In this case, which is interesting, there was actually a criminal prosecution on that issue alone that she violated the restraining order. And in my experience, Casey, I've had clients prosecuted, for merely responding back in a text message, or actually shooting off a text message. In one case that comes to mind is my client was accused of domestic violence, which was proven not true at all. But when he was served with the restraining order, he read it and then within minutes sent the other party a text message that stated, "Thanks for the restraining order." And guess what? He was criminally prosecuted for that because that was a violation of the temporary restraining order. And what you just read there, the Court of Appeal found that violation was way more significant than what the trial court thought it was.
And it makes sense if you think about it because law enforcement they're out in the field. They have to make quick decisions. They're non-attorneys. And if there's a restraining order in their system and there's someone within 100 yards, they need to have the ability to make a judgment call on the spot. They're not going to analyze and go through factors. They know that there's a restraining order with 100 yards and someone is, 50 feet away, they make the decision. They know that there's a restraining order that says no contact and there's a text message. They need to be able to make a decision, arrest the person and protect the victim in that case. So from a public policy standpoint, it makes sense that we should not be analyzing and having mini trials about post-TRO violations. I mean, it is a violation is a violation, period. So beyond that, I like the next step in the analysis, and that is that one of the arguments, it's again addressing each of the pretexts. One of the arguments by the defense counsel is that the defendant had not attempted to physically harm the petitioner since 2018 or communicate with her since 2019. So they're saying, haven't contacted her. The court says the fact that a protective order has proved effective is a good reason for seeking its renewal, not its termination. So I really, really like this language because it's essentially saying, great, that's what it was supposed to do. That's what the restraining order did. It kept you from harassing and contacting and, doing all the other things that you're restrained from doing. So the fact that they did not reach out tends to show that the restraining order is further necessary, and it should not. And it's going a step further and being stronger and saying, and it should not be used to justify its termination.
Cool. So one of the things that I always like to do at the end of these discussions is to ask, what lessons do we learn from this, and what can we give to our audience about the meaning of this case?
It's a great question. Well, there are a couple of things. One of them for me, which is not the main focus of the case, and that is that a police officer didn't testify, and the lower court used that to analyze a very scary, egregious incident as not as serious because there wasn't a police officer that
Yeah,
testified.
it shows you the importance of calling police officers to court to testify to these things. And the sad thing is that these hearings could be expedited, and a court might not give you enough time to actually subpoena an officer. So, we've got to fight for that, obviously.
Right. So I that's kind of an aside, but I think it's something that we take away from this case. What I think is that you really do have to analyze the case, and to keep the court accountable, you really do have to go through the factors. You have to funnel each step through the Ritchie factors to really show what the showing is. If you look at the court's commentary, in fact, we didn't mention this, but it's indicated in here that the court started this by encouraging the parties to find a resolution, a solution, a middle ground, and that's probably inappropriate to do in a case where there was such a serious incident between the parties. And the Court of Appeal, it's actually a footnote, says that, yeah, we should try to encourage settlement, but we're not supposed to be kind of pushing people in one way or the other. That was kind of beyond the scope of what
So you're right on point. I think it's a footnote 1. There are times it may be appropriate for the court to encourage settlement discussions. However, the court should carefully consider the evidence underlying the initial DVRO in assessing whether to do so, particularly in circumstances where the underlying conduct involves significant physical danger. So, in this case, what happened is the judge had said, why don't you guys go out and try to work this out, right? Which we hear all the time because the courts are very busy, they're impacted, we're supposed to be meeting, conferring. And when the petitioner said, Judge, we're not going to work anything out, I want to move forward with it, the comment back was, well, you never know what you're going to get, okay? Because in my experience, people should try to take care of this themselves. Well, let's see what happens. That was almost like, to me, a warning that because you're not listening to me, I'm going to be maybe putting my finger on the scale a little heavier, for you to prove your case. That's how I took it, and stuff. And the Court of Appeal was right, in that there are some cases that have to go to court. When you've got a lot of dollars on the table, for example, and there's gray areas of law, parties aren't going to always be able to settle that. And the same thing with this. If it's very, very egregious, how are you going to settle? You're going to say, well, no, we're going to just make it a 1-year restraining order or something like that? No, of course not. You have to go to court.
Right. So I think to answer your question, Don, I think that you have to know the law very well, because if you know the law very well and you are ready to analyze the case through the law, when you see that a court is doing and saying things that kind of are showing either a confirmatory bias, judge just didn't think this should be renewed, or showing just some sort of bias in general, then you have to redirect back to what the law is and refocus the court and hold the court accountable for analyzing the case through that funnel.
Yeah, and then I'm sorry to interrupt you, but I think that right there is the point, is that look out for the comments of a judge when they seem to be saying something like this that is really inappropriate, and it could be grounds for an appeal. So you want to listen out for those things.
And then that ties into a comment at the end of the case where the lower court did not grant the renewal, but then gave a warning to the defendant that, the Court of Appeal is saying, if you felt that there was a need to admonish the defendant from the bench, then you must think that there is a reason that person needs to be admonished to stay away and have no contact with the petitioner. So if you need to admonish someone, then that's enough to say that the person probably, the petitioner should have said they proved their case.
Yeah.
So again, that was like a piece of conduct from the court that tended to show that the court was not aligning its analysis through the law.
Right. And again, listen to what the judge has to say. If you want to avoid having to come back with an appeal, cite some case law, like this case right here, and say, warning, a person, and stuff, is de facto saying that it was done. And we see that a lot of times, it's like, I'm not going to grant the orders as requested, but let me just say something, sir. If I ever, you hear those type of things all the time. Well, guess what? That's not proper.
Right. And there were just two more areas that the court picked apart. And this whole defense about, oh, I have new medication and I'm better now, just as a kind of cautionary tale, there wasn't sufficient evidence of that. There was no evidence presented other than the testimony. If you're going to put a medical issue or cause on the table, you have to have scientific knowledge, some sort of a medical expert in order to show that. So that was one. The other thing is, as far as a significant change in circumstances, like the other case I mentioned, where the parties moved 300 miles away. In fact, in this case, the defendant had moved to Southern California, closer to where the petitioner now was. So now they're in the same city. So that fact was ignored in the lower court's analysis.
Oh, good. Okay. Well, I think that we've thoroughly examined this case. I hope that our viewers have enjoyed this and learned a lot from it. If you're interested in doing well in family law, if you're going in for a restraining order, either as the accused or the defendant, watching this summary, I think, could help you as long as you were able to follow us. I know we got into the minutia. So, Casey, thank you very, very much again. This was really enlightening, and I hope to see you again soon.
Thank you, Don.
And that concludes Exhibit A, and we'll see you next time.